This is Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. So Donald Trump just filed his reply to the Department of Justice's response to Trump's motion for judicial oversight and additional relief. That's before Judge Eileen Cannon in the Southern District of Florida. We've talked about these proceedings. Watch some of the other MeidasTouch videos where you'll hear more detail about the government's filing, where they laid out in very detailed, factual analyses all of the efforts taken by Trump to obstruct the government from identifying, locating, and retrieving top secret, sensitive, compartmented information that Donald Trump stole from the White House after he left office, the declarations and affirmations made by Trump and his legal team that these top secret documents were returned when they were not, and what was ultimately found at Mar-A-Lago. And we've even talked about the photograph now, the famous photograph, Exhibit F, which just showed a small grouping of the top secret, sensitive, compartmented information found at Mar-A-Lago, which is itself the evidence of the crime. Those are documents that don't belong to Donald Trump. And in terms of the legal arguments that were made by the Department of Justice in their argument where Trump was asking for a special master or the return of the documents, one of the main arguments that the Department of Justice made is that you don't have standing because these documents don't belong to you. You don't own top secret, sensitive, compartmented information when you're no longer the president. Presidents don't own it. I mean, it belongs to the government. You can't steal records and hide them and conceal them at your home resort or whatever weird spot that you live at. You don't own these documents. They're not yours anymore. And then the government also said it's unclear if Trump's asking for an injunction, but he clearly didn't show any probability of success on the merits, or he didn't show any urgency about irreparable harm because he waited 2 or 3 weeks to even file this motion. And then when it came to executive privilege claims, one of the things the government argues, even to this day, Trump has never made an executive privilege claim. He talks about executive privilege on his failing social media company, and he mentions executive privilege in some of his filings, but he hasn't made any declaration of executive privilege over these documents. If he did make them, he wouldn't be allowed to because executive privilege resides with the executive, the current administration. Former presidents don't have executive privilege, and the current administration is not invoking executive privilege and likely couldn't, even if he wanted to, over top secret, sensitive, compartmented information that doesn't reflect the private deliberations of the executive branch anyway. But in any event, that's not being invoked. And then this idea that there should be a special master. Special masters are usually only appointed in very limited circumstances, the government pointed out, where it involves a search warrant of an attorney or a law firm, and because there could be attorney-client privilege documents that are intermingled, that's really the rare examples where a special master would occur. But in any way, the idea of a special master here is particularly moot because all of the documents have been reviewed already. There was a protocol in place about how privileged documents would be dealt with, and the only potential privileged documents here are maybe attorney-client privilege records, which have been segregated, and there's a process in which the DOJ and Trump's lawyers can deal with those attorney-client privilege records. But in any event, there is no need for a special master at this point, is what the DOJ argued. So Donald Trump files this real gibberish response. And I like to give you detailed analysis and try to break down motions, but sometimes when a motion's so incomprehensible, it's very hard to break down the points that are being made. But first, from the outset, let me say that this motion is completely gibberish. It barely even understands what the law is. And one of the things, for example, it says is there isn't a need for a possessory interest over a property for a party to seek the return of property under the Fourth Amendment and under Federal Rule 41G and E, which deal with the return of property after a search warrant's executed and property is seized. Just think about that Trump's arguing that there is no requirement for a possessory interest, to possess it, to own it. That clearly makes no sense. In order for you to reclaim property, you have to own the property. You have to say the property is yours. It has to belong to you. And this property doesn't belong to Trump at all. One of the other things that it basically says too is it goes, despite the clear desperation of the government in avoiding the broad parameters of the Presidential Records Act and allowing the president to possess documents. Again, they don't understand in this motion what the Presidential Records Act is, what records could belong to someone, individual records, what records belong to the government. And one of the things that he keeps reiterating in this motion, which I think is, incriminating over and over again, is he's saying that these documents, he believes because he was the president, he should keep. He should maintain all of these records and that they belong to him because they existed at the time that he was the president. But that's just not what the law is. And they seem to think that the Presidential Records Act, they go, has no enforcement mechanism, and the president, a former president, can do whatever he wants. And this is one of the arguments they parroted over and over again. They go, there is no criminal liability for stealing state secrets when you're the president, which is utterly absurd. And it's not a complicated point. I mean, you have the Espionage Act, you have the obstruction statute, you have the concealment and mutilation statute, which all spell out the crimes of stealing documents, regardless of classification status, that belong to the national security apparatus and don't belong to private citizens. As a private citizen now, you don't have any claim whatsoever to it. Even presidents can't just go and start stealing records whenever they want. And so it's, again, just totally, utterly absurd right here. One of the things, too, that they say here in this motion, which perplexed me, is they go, this is what Trump says, the purported justification for the initiation of the criminal probe was the alleged discovery of sensitive information contained within the 15 boxes of presidential records. But this discovery, they put that in quotes, was to be fully anticipated given the very nature of presidential records. No, it wasn't. Again, he's kind of admitting to criminal liability here. There's no former president who stole top secret, sensitive, compartmented information after they're no longer the president and brought it to their home and just kept it in their desk drawer and in storage spaces. No, it was not to be anticipated that you would have top secret documents shredded and concealed within other random boxes. That's not the case. And then also to lie and lie and lie to the government that you've turned over all of the records when you didn't is also a crime as well. And one of the things here, though, that you really ask, what is Trump asking for? What is he looking for? He talks about the special master. He again ignores the fact that special masters, one would have to have one top secret, sensitive, compartmented information. Trump ignores the fact that the issue is moot at this point because all of the documents have already been reviewed. And he also ignores the fact that the very small circumstances where you have a special master are really search warrants on law firms where there's a ton of records, not a very small set of documents. But what is Trump trying to get at here? What does he actually want? Well, what he's asking the special master to do, and what he's asking the judge to grant him, is to basically seize and reclaim all of the records. And so we're talking not just about this subset of attorney-client privilege records. What Trump wants the special master to get is the documents that are currently being reviewed by the Office of Director of National Intelligence to determine how damaging those are to our national security interests based on Trump concealing it and based on Trump stealing it from the White House. He wants those documents to snatch them from the ODNI. That's one of the things that he wants. And so he wants a record of all of these to go to the special master. He wants to see everything and basically wants to force the executive branch, the current executive branch, Biden, to give a former president these records back. I mean, good luck with that, but it highlights the absurdity and just the very lack of knowledge at all. And there's just also misrepresentations of the fact. Again, Trump tries to portray the situation as, oh, well, it's just he was doing what the government said. I mean, why would the government do the search warrant on August 8th? That came out of nowhere. He was being collegial and doing everything they said. We know that to be completely and utterly false. And so that's basically the summary of all of the things here. I mean, there's really nothing that new in here other than, again, Trump basically saying he doesn't need to have a possessory interest. In any event, he owns all of these records that belong to the current executive branch. So he believes he should have them. He believes that the role of former presidents are that they could do whatever they want, steal records, that there are no rules that apply to him. And frankly, as I read his motion, not only is it gibberish, but it looks like he's essentially admitting to criminal liability, perhaps without realizing it. So what happens next? There will be a hearing on September 1st before Judge Eileen Cannon. We will obviously be covering that hearing here on the MeidasTouch Network. So make sure you hit the subscribe button now so you can follow those updates. But I mean, the law is absolutely clear on here. There should not be a special master. It's completely against the law. It's moot. Trump doesn't have a possessory interest. Trump's lawyers don't know what they're talking about. The Department of Justice will have its A team there. Trump will have whatever team that wrote this there. And we'll keep you updated. The one variable here is that the judge who Trump drew is Eileen Cannon, someone he appointed in 2020. And she did previously say she was inclined to have a special master, but she didn't know what the law was. In fact, a group of former prosecutors, and we're talking bipartisan, top Republican and Democrat prosecutors, had to write what's called an amicus curiae brief, which is called also known as a friend of the court brief. And we usually see amicus briefs filed in Supreme Court cases. And so it's rare to see those types of briefs filed in district court cases because they're usually at like the highest level of cases before the Supreme Court. But here, obviously, the implications are serious. But all of these federal prosecutors filed this motion before the Department of Justice filed its response just to try to educate this judge. Judge, let me explain to you what executive privilege is. Let me explain to you why special masters would not only be inappropriate here, but would harm our national security here. Let me just explain to you, Judge, as federal prosecutors, Democrats, Republicans, this is not a partisan issue, what the situation is here. Then the Department of Justice filed their motion, and now we see that Trump filed this gibberish reply that, frankly, I think further goes to incriminate him. So this is Ben Meiselas from the MeidasTouch Network. Thank you so much for all of your support, and continue to support MeidasTouch Network. We are the fastest growing independent media company in the world, but as many of our commentators pointed out, you're not just a media company, and stop just saying that. It sounds so sterile, and that commentator was right. The MeidasTouch Network is a community. The MeidasTouch Network is really nowhere without you and without your support. And we appreciate this movement together, fighting for pro-democracy, and frankly, rethinking, reimagining the news in a way that just tells the facts, calls traitors traitors, calls fascists fascists, doesn't both sides the issues, gives you the facts that when you have talking heads yelling at each other, you're not able to really get and digest the issues. And what I ask you do now is a few things. One, spread the message. Number two, you can subscribe to the MeidasTouch podcast to get updates with me and my younger brother. So go right now wherever you get your audio and subscribe to the MeidasTouch podcast right now. You could also subscribe to the Legal AF podcast. Also subscribe to this YouTube channel. Those are the best ways that you can help support the MeidasTouch Network. And of course, by continuing to watch these videos, share these videos, send these videos out. Let's spread the truth. Let's spread love. Let's spread democracy. Ben Meiselas signing off.
MeidasTouch is unapologetically pro-democracy. And look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs, It Wasn't Rigged, You're Just a Loser, at store.meidastouch.com. That's store.meidastouch.com.